bring about. This undermines trust, and the result is that courts and arbitrators are called in to fill the gaps. There is little doubt that the economic future is uncertain. We are facing the most dramatic decrease in economic activity in a generation. The latest figures from the UN Conference on Trade and Development are startling. In the first half of 2020, global foreign direct investment flows fell by 49%, reducing almost by half. Developed economies saw the biggest fall, with a decline of 75% compared to 2019. Inflows into Europe were negative, flows to North America fell by 56%. Global foreign direct investment is projected to contract by about 30 to 40% for the full year 2020. The rate of decline in developed economies is likely to flatten as some investment activity appears to be picking up in the third quarter. Flows to developing economies are expected to stabilize, with East Asia showing early signs of recovery. But significant uncertainty remains, with the outlook depending on the duration of the health crisis and on the effectiveness of policies to mitigate the economic impact. In short, amidst all this uncertainty, there appears to be one thing we can know with confidence. We practitioners will increasingly be called on to assist parties in navigating their disputes as the world navigates this unprecedented challenge. Second, turning to the concrete problems of clients, the pandemic has disrupted and continues to disrupt the foundations of global trade across all sectors: supply chains, currency and market stability, risk assessment and insurance, to name but a few. As practitioners seek to protect their clients from these disruptions, we are testing the limits of established legal concepts, such as the application of force majeure and material adverse changes clauses, as well as doctrines of impossibility, impracticality, and frustration of purpose. These once perennial issues are now evergreen in the time of the pandemic. Similarly, the topics to be addressed today, the validity of arbitration clauses, the law applicable to the agreement to arbitrate, a timely issue addressed just last month by the UK Supreme Court in the Anker and Chubb case, how to deploy experts and most effectively present their evidence, and how to handle conflicts of interest, all have become even more critical. Third, I'd like to focus on the law leaders of tomorrow, many of whom are at this conference, I expect. I'm certain none of you expected to begin your career in a pandemic. Yet crisis and adversity not only make us stronger, they yield opportunities for innovation. This experience will strengthen the next generation of practitioners. It will sharpen their problem solving, enhance their use of technology, and ultimately make them better advocates for their clients in good and bad times. I applaud the Moot Alumni Association of the Wyss Moot Court for organizing this conference and for carrying on the goals of the Wyss. May you continue in strength to promote the resolution of international business disputes through consideration of concrete problems of clients and by providing a forum for dialogue and the exchange of ideas with the law leaders of tomorrow. Thank you for your attention. I hope that you enjoy productive and fruitful discussions in the sessions that follow.
Thank you, Emma. Hopefully you can hear me now. Possibly still not, but thank you very much for the welcome. Turning now to the first panel, which I happen to be a member of, but I also get to introduce the first panel, at the very least, our moderator, Dr. James Ding. All of the bios are available on the Hong Kong Legal Week website, so we do invite you to take a look at our speakers' profiles and pictures. But to give a brief introduction, Dr. Ding is the Commissioner of Inclusive Dispute Avoidance and Resolution Office, Department of Justice of the Hong Kong Special Administrative Region. Dr. Ding actually is very prevalent in international law, and he has published on various subjects in international law and international cooperation. He is also the chair of the APEC Economic Committee, and I've had the benefit of meeting him at multiple conferences where we've had very good exchanges. What I will do now is turn it over to Dr. Ding, James, as our moderator today, and let this panel proceed.
Thank you, Janine. It's my pleasure to moderate this distinguished panel. First of all, I would like to thank the organizers, in particular the Boots Alumni Associations, for participating in the Hong Kong Legal Week. And in this beautiful building, the former French missionary building, that's part of the Legal Hub, Hong Kong Legal Hub, and just officially opened on Monday. So I'm very pleased to have our distinguished speakers with us today at this beautiful building. And at these sessions, we are going to discuss about chasing the asymmetries in arbitration causes to be or not to be valid. I am not sure if everyone is familiar with the symmetries of arbitration causes. Just to make sure that we are on the same ground, I will just give a very brief introduction before I pass the floor to the panelists to share their expertise. Basically, asymmetric arbitration causes is, in a simple term, is not symmetrical. In symmetrical arbitration causes, the parties will mutually agree to use arbitrations and agree to a set of arbitrations. But for asymmetric arbitration causes, or sometimes called unilateral options arbitration causes, one party would have the right to choose to resort to disputes to arbitrations and to choose an arbitrations, and perhaps with some other rights that the other parties do not have. In this kind of cases, we call them asymmetric arbitration causes. Such causes has been used in some particular industries, for example, in some finance contracts, and is more commonly found in some finance contracts. The lenders usually would have the right to choose the pace of arbitrations because the lender would like to choose the venue of arbitration where the borrowers has access. So this gives the lenders the flexibility, and it's also part of the risk management technique. However, the legal positions on the validity of this kind of asymmetric arbitration causes is not the same across different jurisdictions. So today we will discuss from our panelists whether this kind of asymmetric causes is valid or not valid in different jurisdictions, in common law and in civil law jurisdictions. So we will have fruitful discussions. Our main focus for this panel will be on the validity of these kind of causes. Before I pass the floor to the panelists, I will briefly introduce our distinguished panelists today. We have panelists here in this building and also panelists on the online. We have Dr. Helena Chan. She should be joining us online. Maybe we'll see her on the screen shortly. She is a partner and joint head of office for Prince Masons in Beijing, and she is a qualified attorney in New York, Taiwan, and mainland China. She acts as both arbitrators and legal counsel focusing on arbitrations, infrastructure projects, and cross-border investment. We also have Living New Line with us today, the gentleman here. He is a senior associate with Sidney Austin based in Hong Kong, and he's qualified as an attorney in New York and is a registered foreign lawyer in Hong Kong. He his practice focus on international arbitration and dispute resolutions, including white-collar litigations and internal investigations. Charlene Tong, everyone knows her, but I still have to introduce her. She's a partner with us worldwide, based in Hong Kong. She's qualified as an attorney in California, New York, and is a registered foreign lawyer in Hong Kong. She also is the president of the Woods Alumni Association and director of the board of the Woods Vienna and West East Foundations. And on my right is Brianna Yan. She is the professional support consultant and practice manager in Herbert Smith Freehills, Greater China Arbitration Practice. She is qualified as a solicitor in England and Wales and a registered foreign lawyer in Hong Kong. She is also the vice chair of the Hong Kong International Arbitration Center and acts as an arbitrator. So we have a panel of 4 speakers, and we'll adopt an interactive format for our panel discussions. So I will throw some questions for
James, I'm going to interrupt you really quickly. We just want to double check that Dr. Chan or Helena is actually with us today because she's not on the screen. Do we know if she's in yet? She hasn't entered the room yet. So if you could bear with us for 20 seconds. She's going to unmute.
Yes,
There
we have
she
her.
is.
Yeah, yeah.
Hello, Helena.
Can you hear us?
You see her name? Ooh, we heard something.
Hello? Hello, Hannah?
I suppose perhaps without delaying, because we've already kind of started off a little bit late, would it make sense maybe if we put Helena start?
Yeah, maybe while the technicians are fixing the issues, we can start discussing some of the
We can have
issues.
a nice
yeah.
discussion on asymmetrical
Yeah.
arbitration agreements, you know? What would we, I mean, I guess before, we don't really want to enter the discussion before Helena comes in, but it just seems, if I start a little bit of a conversation, Brianna, have you really, what is it with asymmetrical arbitration agreements, perhaps from a client's perspective?
I think, is that working?
Yes.
Okay. I think from the client's perspective, really depends obviously who the client is and where they are in the transaction. Certainly in my experience where we see these clauses most often is in finance transactions, where it's typically a loan agreement where the lender is contracting with a borrower, and in that situation naturally you have an imbalance of bargaining power and you also have different interests. So typically you will see the lender agree an exclusive jurisdiction clause, for example the Hong Kong courts, the New York courts, and that binds the borrower. On top of that, the lender will preserve the option to litigate or arbitrate elsewhere, and that's driven by very simple, quite obvious considerations that the lender wants to be able to enforce against a defaulting buyer wherever that borrower has assets, essentially. So if the lender can see that there are assets outside the court the borrower has agreed to, then it can pursue those assets either in the courts where those assets are located, or what we see more often is the lender preserving the option to arbitrate. And by doing that, the lender gets two benefits. It gets the benefit of being able to go after the assets wherever they happen to be, and it gets the ease of enforcement that comes with an arbitral award as compared to trying to enforce a foreign judgment in the location where the assets are.
Yeah, no, that makes sense. And I mean, I think I've also seen it in, outside of just from the financial perspective, I've seen it a lot in clients who manufacture products or sell products, but their manufacturers are in Asia. Because sometimes they want to be able to have the election to go after the manufacturers if they're commencing the suit. But it was nice to, because I was reading it and I said, oh, financial agreements, this is a different twist on it. Clearly we're still going to have some conversations on this. So actually, Nathaniel, I'm going to turn it over to you.
Is this working?
It is working. So what about from your perspective, your time with Sidley and your past, have you come across a lot of asymmetrical clauses?
Yeah, so I've come across these types of clauses in fund documents, actually. We've had fund clients who sometimes are interested in putting these sorts of clauses in their agreements with investors. Right, typically the idea would be for the fund to force the investor to go to arbitration, but for the fund to sort of preserve the right to bring suit against the investor in their home jurisdiction. But these have been few and far between. But I've seen some fund clients try for this, and usually, right, I think as Brianna has mentioned, there is some sort of sort of inequality in bargaining power, where the fund is like a large fund, right, and the investors tend to be smaller, right, as a way to sort of, to preserve some sort of advantage in dispute resolution. I think beyond that, I mean, we've seen it come up in consumer contracts a lot in the U.S., and we'll come to that, but that's where a lot of the cases in the U.S. have fallen. Yeah.
So anyways, we've got Helena. Can you hear us now? She's Helena. Ooh. So as you guys can tell, this is the very first panel for the Generations in Arbitration conference. So we're also the guinea pigs of making sure the technology works in a hybrid conference. Helena, how's it going over there? So, okay, as we continue to work on Helena.
We'll try to fix the issue as soon as possible.
No, that's okay. I mean, it's a good conversation. So, James, I'm kind of taking over your role. I'm sorry.
No problem. Yeah.
That just means I don't have to speak as much on the substantive aspects. But, James, can I ask you a question?
Yes,
I think,
sure.
does the DOJ, or at least from your role within the DOJ and your colleagues, do they take an interest in the asymmetrical arbitration agreements?
For us, our task is pretty easy because in Hong Kong, the legal position is quite clear. It's valid and enforceable. So it hasn't presented much an issue for us. Yeah.
Okay.
So actually, we encourage the parties to choose Hong Kong as their arbitration seat because we have very certainty.
I completely agree, Brianna. I think you could support this in your role.
Absolutely, do support this, and we're very lucky here in that, broadly, the court's approach is supportive of parties' autonomy, supportive of their agreements, and very supportive of their rights to arbitrate if that's what they select. So it's usually a sort of short but easy answer from Hong Kong.
Exactly, and just for the both of you to correct me, I would also think, taking a look at this again, at the asymmetrical unilateral arbitration agreements, with the seat being Hong Kong, or with the governing law being Hong Kong, it also shows that Hong Kong is much more supportive, well, I may get myself in trouble of this, is a big supporter of party autonomy, allowing the parties to make that decision.
Absolutely. And I think the common law cases, certainly the ones I've looked at, particularly in the context of Hong Kong and of the UK, of England, are broadly supportive of that. And the view is that just because there's an imbalance in bargaining power, that in itself is not a reason.
Sorry that I cannot hear anything.
We win, but we can hear you. Can you hear us? No, we can hear you.
Oh, now I can hear.
There we
good,
go.
good,
Helena, can you hear us?
Yeah. Now I can hear you now.
Hi, good morning. Very good to have you. Sorry,
Good morning.
you're our guinea pig.
Sorry for this technical
No.
issues.
You are our guinea pig, and we're going to figure out how to make the rest of the day work very smoothly. So what we've done on this end is James has given us a very wonderful introduction, as well as the introduction for the panel itself. What I will do now is I'm going to give the job back to James to be the moderator. And James, you can take it from here?
Sure. And then we're just talking about the practice in different jurisdictions on the asymmetric arbitration clauses, and we just talk about Hong Kong, UK. How about the other common law jurisdictions, say Singapore, Malaysia,
Yeah, I think so. If we can start going back, going first into a more in-depth approach. Brianna, let's start with Hong Kong. I know you've already done some case research, but maybe, and we all know that it's valid, but...
Yep, absolutely. So in the arbitration context, the position, as James says, is clear, that Hong Kong will generally uphold an asymmetric clause that provides that both parties can litigate, but one party retains the option to arbitrate, or the other way around. The key case in Hong Kong is a 2001 case, so it's well established, called China Merchants Heavy Industry and JGC Group. And the judgment there, it sets it out in terms, clauses where one party has the right to choose arbitration, or where arbitration is at the election of either party, are allowable. But subject to the proviso that the clause has to be sufficiently certain to be an enforceable arbitration agreement. And you'll see that theme run through both the common and the civil law cases, and it's obvious that it needs to be a valid arbitration agreement first and foremost before a court will enforce it, whether as an arbitration agreement pure and simple or as an option clause. And unsurprisingly, when Hong Kong made that decision in 2001, it relied on an English case from the 80s. And as we'll see, the English position is broadly the same, supportive. Interestingly, though, there's a very recent case from earlier this year, not in the arbitration context, where there was an asymmetrical court jurisdiction clause. It was a case between the bank, ICBC, and a party called Wisdom Top International. And that was looking specifically at an application to enforce the agreement in the context of the arrangement between Hong Kong and mainland China for the enforcement of judgments. And there the judge found that an asymmetrical clause was not an exclusive jurisdiction clause. So for those who don't know, the Hong Kong mainland judgments arrangement requires that the judgment be made pursuant to an exclusive jurisdiction clause. The judge found that for the benefit of the respondent party, Wisdom Top, the non-bank, the clause was exclusive because it had no option to litigate elsewhere, but the bank had an option. It could litigate in Hong Kong or elsewhere, and therefore it was not an exclusive jurisdiction clause for the purposes of enforcing under the arrangement, and enforcement was refused. So quite an interesting approach. And as we come on to some of the English cases and the French cases which wrap in EU law, that requirement that the clause be an exclusive jurisdiction clause becomes very relevant throughout.
Very interesting, yeah. So let's hear from the other common law jurisdictions, maybe.
So Nathaniel,
Yeah.
do you want to maybe start, if it works for you, we can go,
Sure.
I thought Hong Kong, Singapore.
Sure, I can cover off Singapore then.
Don't worry, I'm coming back to you for the US. You're not getting off easy.
All right. So I think that like Hong Kong and I think England, in Singapore, asymmetric agreements, arbitration agreements are valid and enforceable. The leading case from Singapore on this is the Singapore Court of Appeal decision in a case called Dynajet Private Limited against Wilson Taylor Asia Pacific Private Limited. It's a 2017 case. And I think this is the first time that the Court of Appeal has ruled on the validity of an asymmetric and optional arbitration clause under Singapore law. It's quite an interesting case because of the way the parties ran it, so I think it's worth going into some detail. The clause in that agreement said, in terms, right, if no amicable settlement is reached through discussions at the election of Dynajet, this is the optional part, the dispute may be referred to and personally settled by means of arbitration proceedings conducted under English law held in Singapore, so Singapore C. In that case, so Dynajet decided not to arbitrate, so it took the case to court, filing suit in the Singapore courts. And Wilson Taylor, i.e. the party that did not have the right to take the disputes to arbitration, sued for a stay in Singapore courts under the Singapore Arbitration Act, the International Arbitration Act. And so as part of his analysis on whether to grant a stay under the International Arbitration Statute, the court had to consider a number of questions. First, whether there was a valid arbitration agreement. The court held that this optional arbitration agreement was a valid arbitration agreement, and it stated quite explicitly it was immaterial for this purpose, that it entitled only one party but not the other to compel its counterparty to arbitrate a dispute. So it didn't care that there was so-called lack of mutuality, doesn't affect the validity of the arbitration agreement. Court also held that it didn't matter that the arbitration agreement made arbitration of a future dispute entirely optional instead of placing parties under an immediate obligation to arbitrate their dispute, right, which the court called the optionality characteristic. Neither of these sort of features of the arbitration agreement in Dynajet serve to affect the validity or the enforceability of the arbitration agreement. And the interesting part is actually the second question the court considered, which was whether the dispute before the court fell within the scope of the arbitration agreement, such that it would merit a stay of the proceedings in court. And here the court said, well, only Dynajet has the power, the option to enforce arbitration. Wilson Taylor does not, right? And so given that Dynajet elected not to take the dispute to arbitration, right, this dispute did not fall within the scope of the arbitration agreement, and so the court denied a stay, right? So in other words, the court not only upheld the validity of the arbitration agreement, the court sort of explicitly upheld the optionality inherent in this arbitration agreement, expressly holding that, right, there's no issue with only one party but not the other having the right to go to arbitration.
Right.
And so basically, right, it denied Wilson Taylor the rights, so to speak, under the International Arbitration Statute associated with arbitration, because Wilson Taylor did not have the right to take the dispute to arbitration in the first place.
Nice.
Yes, thank you. I think the position in Singapore is a bit similar to Hong Kong as well, and we pay full respect to parties' autonomy in this regard.
Yeah.
How about the United States? Shelley, it's your area, yeah.
But actually, before we jump to me, if you don't mind, James, I was actually going to pop it back to Brianna. I've been informed multiple times that while the U.S. is considered a common law jurisdiction, we are special. But I think maybe we can take a look at the UK perspective in line with Hong Kong and Singapore.
The
Then
more
we come
similar,
to the special
sure,
common law
sure.
jurisdiction.
Okay.
So yes, I mean, we've already said it, England and Wales as a jurisdiction is supportive of these clauses, has been since the mid-80s. And essentially the principle is that English courts will uphold the party's choice. So it is, again, full support for party autonomy. If there was free rights to negotiate, which is not the same as equal bargaining power, but if the clause was freely negotiated, the English courts will uphold it, unless there are overwhelming or at least very strong reasons for departing from this rule. What is important in the English courts is that the clause be predictable, so that even if it's unilateral or asymmetric, it's clear what the options are, who can exercise them, and when they can be exercised. And that requirement tips up in civil jurisdictions as well. One of the main cases in England is a 1998 case between Credit Suisse and a company called MLC, Bermuda Incorporated. That upheld a clause that gave the English courts jurisdiction, but Credit Suisse had the right to take proceedings in any other court of competent jurisdiction. So quite a broad option, but still clear, foreseeable, and back to the point I was making earlier, logical in that if you're the bank and you can't find assets in England to enforce against in the English courts, you want to be able to go to Bermuda or wherever else those assets are located. The case in England that upholds the validity of optional arbitration clauses is called NB3 Shipping and Harebell. And again, it's similar principles, but in that case, the clause provided an option to arbitrate. One of the more recent cases was Commerzbank and a company called Pauline Shipping and Liquimar. And that held, sort of conversely to the case I just mentioned in Hong Kong, that a unilateral option to litigate in a court other than the English courts did qualify as an exclusive jurisdiction clause. And this is specifically in the context of the recast Brussels regulation. So this is where English law and EU law start to dovetail. Most of our audience, I'm sure, will know that for a judgment to be enforceable from one EU state to the other, it has to be made pursuant to an exclusive jurisdiction clause, again, similar to the Hong Kong-China mutual arrangement. so this Commerzbank case in 2017, the English courts held that a clause that gave both parties the right to litigate in England, but one the option to litigate elsewhere, was exclusive for the purpose of, for the purposes of the non-optional party, the party that did not hold the option. And in the EU, that translates into a requirement that the court that's first seized must stay its proceedings in favour of the court that holds exclusive jurisdiction under the clause. And there are a couple of more recent cases, 2019 and I think 2020, Etihad Airways, and also another case called NN2 Newco, both of which uphold this principle. So it really is a case of who has the option, whether or not the clause is exclusive in the hands of the other party, and whether the clause was freely negotiated and the option is clearly determined and objectively predictable. That's it.
Interesting cases, yeah. So back to you, Shailene, the special common law jurisdictions.
Just trying to get out of this. No, but so thank you, James. What Nathaniel and I thought we would buddy up and discuss what perhaps is not necessarily the case law or is necessarily the case law in the U.S. As Nathaniel mentioned earlier, most of these cases involving asymmetrical clauses involve consumer disputes, and also I would add on to that, from our research, we also found a lot of employment disputes. My opinion, which obviously can and will likely be challenged, and maybe I will be proven. Oh, now you can hear me. Oh, but that was the whole point. I didn't want you to hear everything. My opinion is the reason why most of these cases do actually come to the courts is because it's the consumer and the employer situation is oftentimes you see unequal bargaining power or employees who have no choice but to sign a contract even if they disagree with such type of an asymmetrical clause. From experience, we haven't actually seen yet an international dispute brought to the U.S. courts, whether federal or state, involving an asymmetrical arbitration clause in a cross-border dispute involving sophisticated parties. Again, this may be different. We haven't found any yet. This may still come to light. I believe that these cases, though, are focused on state law. So what we have found in instances where a court, state or federal court, has in fact rejected or invalidated an asymmetrical clause in a contract are oftentimes, for example, in California, employment disputes. I know there are two particular cases quite famous involving Circuit City, which is used to be a huge electronics store chain in the U.S., and they involved two employee disputes where the employees raised allegations of sexual harassment. They filed suit in the state courts and also federal courts in California, and Circuit City came in and tried to stay the proceedings in lieu of arbitration. The court ultimately found that the litigation could proceed because the asymmetrical agreements in such contracts were invalid. This is from the perspective of, I guess, an employment contract, but also under California law. I know that this has also been upheld in other states, such as Minnesota, Maryland, I believe. But before proceeding, I'm actually going to flip it back over to Nathaniel on cases where they have upheld asymmetrical clauses.
Yes, so there are a couple of cases where these sorts of clauses have been upheld in the US. And interestingly, these seem to be sort of older cases. So I mean, the one I have here is a Third Circuit case from 1999 applying Pennsylvania law. And again, right, typically the two arguments that are raised in these sorts of asymmetric arbitration clause disputes is sort of the concept of mutuality and the concept of unconscionability. Mutuality being the objection that sort of there's an imbalance in the substantive obligation, i.e., right, whereas I can take you to both court and arbitration, you can only take me to arbitration. And in this case, right, in some cases, I think in this particular case, the court held that this wasn't an issue because, right, there was consideration inherent in the entire contract, and there's nothing sort of under Pennsylvania contract law that requires equivalency of obligation in order for an arbitration clause to be valid. And then, right, the court moved on to talk about unconscionability. And here it said basically it's the same as neutrality and sort of dismissed the issue, finding that, right, the mere fact that one party retains the option to litigate some issues in court while the other party must arbitrate all claims does not make the arbitration agreement, right, per se unconscionable. Right, yeah, so in this case, I think I've got to give you the name of the case. It's called Harris against Greentree Financial Court. And in this case, I think if you look at the case, there are a couple of older cases it refers to citing basically the same principles. Back to you.
Back to me. What I would say, the trend that we've been seeing in the state courts, also the federal courts applying state law, is asymmetrical clauses generally are upheld unless you see some type of unconscionability or where it really is an employee or consumer that's been forced to sign a contract without having the ability to negotiate. I was actually mentioning earlier, whilst I was at the ICC in New York, we had a series of cases from an international employer with their employees who also had issues with their contracts. But in those contracts, there was an ICC arbitration agreement, where they would have to resolve the disputes via ICC. Now, these disputes that came in, I think the year that I was handling these disputes in New York, we had about 20 of such cases, and each of the amount in disputes were 20,000 US dollars. And of course, the employees raised the argument of unconscionability, and they were forced to sign such agreements. Unfortunately, I didn't stay at the ICC long enough to see it to the end of the case, but I do know that all of those cases did proceed. I would assume they settled. But it does seem to be that the US, actually under US state laws, et cetera, are in favor or they lean towards upholding such agreements. James, I turn it back to you.
Thank you. Interesting position in the United States, so that different decisions, inconsistent decisions, but as Charlene said, it's generally upheld, but subject to some exceptions on the contributory or other public policy grounds, maybe. I think we have quite a bit discussion about the common law jurisdictions. I think it's time we move and look at the other, some civil law jurisdictions. And Helena, you are now in Beijing. Yeah, maybe we start about the position in China.
I'm currently in Taipei, but I would be happy to share some jurisprudence in mainland China and Taiwan with regard to the validity of an asymmetry arbitration clause in these two jurisdictions. First, about the jurisprudence in mainland China. Back in 1999, the Beijing High Court promulgated some opinions of Beijing High Court on several issues concerning the applicable law regarding validity of arbitration clause and the revocation of arbitral awards. Article 5 of this opinion specifically provides that an obviously unfair arbitration clause shall be held invalid by Chinese court. For example, a clause providing that disputes shall be referred to an arbitration institution as deemed appropriate by the seller, only one of the parties. That kind of clause shall be held invalid under these opinions. It was in 1999. Later, more recently, 2015, in another case concerning disputes arising from purchase orders between a seller and the buyer, the arbitration clause provides that any of the parties may refer dispute to CTAC. Meanwhile, it also provides that in all cases, the seller shall be entitled to bring action against the buyer before the courts of the domicile or registered office of the buyer. So this is imbalance. Only the seller can bring actions against the buyer to the courts. such arbitration clause was held invalid by the Beijing High Court, not on the grounds that it was asymmetric. It was on the grounds that it refers both to arbitration and litigation. Under PRC law, if a clause refers to both arbitration and litigation, it would be deemed invalid because there was no clear intention to resolve disputes through arbitration. In another case, 2017, the arbitration clause provides that disputes shall be referred to an arbitration commission designated by Party A. The Supreme People's Court took a very different view. It held that such clause was agreed by the parties after their negotiation and thus shall be held valid. Some Chinese scholars believe that the PRC courts are gradually changing their traditional views towards acknowledging the validity of an asymmetric clause. I believe that we would need to keep observing if there will be more cases supporting the validity of such clause. And then let me talk about two cases in Taiwan. Back in 1990s, the Taiwanese court has upheld the validity of an asymmetric arbitration. In some dispute resolution clauses provided in the model contract between contractors and some government agencies, for example, the Department of the Rapid Transition System. Only the contractors may refer dispute to arbitration after the contractors has gone through several layers of pre-arbitration proceedings, including submitting the disputes to engineers for their decision. And then if the contractors are not happy with the decisions of the engineers, they can, within a certain period of time, refer the dispute to arbitration after they receive the engineer's decision. In contrast, the Department of Rapid Transition System may not refer dispute to arbitration. It was the so-called one-way arbitration clause, which has been held valid by some Taiwanese court in several cases back in 1990s. More recently, in 2012, there has been a very interesting case. It is interesting, I think, because it concerns disputes arising from a letter of engagement between an individual and a law firm. In the engagement letter, it was provided that any disputes arising from the engagement letter should be referred to arbitration administered by any domestic or foreign arbitration institutions as designated by the law firm, unsurprisingly. Then after the dispute arises, the individual disregard this arbitration clause and bring an action to the Taiwan Taipei District Court because the law firm designated a foreign arbitration institution, the Singapore International Arbitration Center, as the institution to administer arbitrations. Then the court held that the parties' agreement to submit a dispute to arbitration shall be held valid because it's the agreement between the parties. Nonetheless, given that all the parties involved are Taiwanese, and the letter of engagement was actually signed in Taipei, there have been no foreign-related elements at all in this matter. Therefore, the law firm's designation of SIAC as the institution to administer arbitration is obviously unfair to the individual, the Taiwanese citizen, and a clear attempt to circumvent the Taiwanese law. Therefore, such designation of SIAC by the law firm shall be held invalid. The court then directed the plaintiff to file a complaint with a local arbitration institution in Taiwan. So it's very interesting. I think generally this asymmetric arbitration clause is generally held valid in Taiwan, sometimes with some modification as the case that I just mentioned.
Thank you,
So
Helena.
that's the situation in mainland China and Taiwan.
Thank you, Helena. So we see that even in the Greater China regions, there are different practices, and so some courts held that the asymmetric arbitration clauses are valid, and some are saying the contrary. But as Helena said, in the mainland China, it seems there's a more recent trend that there's some, maybe perhaps some change of practice. But now let's move further from Asia. Let's go to Europe. Vienna, you just mentioned about EU and Europe, and how about the big jurisdictions in Europe or France? So
the position gets a bit less clear when you get to France. France is on the list of problematic jurisdictions when it comes to these clauses, unfortunately. Problematic because the position is not 100% clear. And so if you are thinking of putting an optional clause into a contract where the arbitration agreement may need to be enforced in France, you need to think very carefully about whether you do it at all, and if so, how you draft it. The lead case here is Madame X and Rothschild, which is a 2012 case. Madame X was a Spanish individual, and she had deposited a large amount of money at Rothschild. The agreement contained a Luxembourg jurisdiction clause with an option to litigate in other courts, I think in any other jurisdiction from memory. The French Cour de Cassation, the highest court in France, found that the clause was invalid because it breached Article 23 of the recast Brussels regulation, the old Brussels regulation, in fact. And that's the article that provides that if EU parties agree an exclusive jurisdiction clause in favor of an EU member state's court, that clause has jurisdiction, and any court that is seized instead has to stay its proceedings in favor of the agreed court. So that decision was quite controversial at the time. The court held that the clause was objectionable because it was what the French courts call potestative, which means that it was negotiated in a situation where one party holds all of the power and the other has no ability to alter or really freely negotiate the clause. And it sort of translates into a lack of mutuality, which I guess also translates into unconscionability. I mean, certainly to my mind, they're all broadly saying the same thing. But in France, this concept of potestative agreements are objectionable. That case attracted a lot of criticism. The French courts then went on to uphold that view a few years later in a case between Credit Suisse and a party called Dan, and really confirmed their objection to this type of clause. But they made clear that from their point of view, again, the issues are predictability of how the clause will operate and where you might be sued, and legal certainty, how the clause works in practice, how you exercise the option. However, more recently, there's a clause called MJA and Apple Sales, a case called MJA and Apple Sales, in which an asymmetric jurisdiction clause was held valid because it objectively identified the courts which could have jurisdiction, which in this case was the Irish courts, or the court where the reseller, one of the parties, had its corporate seat, or any jurisdiction where harm to the reseller is occurring. So again, very broad, but entirely foreseeable and predictable. Now, it's worth pointing out that all of those cases involved optional court clauses, no arbitration element. Our house view has been that clauses with an option to arbitrate may be less objectionable to the French courts, but the general message is you have to treat these clauses with caution if there's any French element, basically.
Thanks, Brianna. So the positions in France is less clear, not so certain. But that's something that we have to look out for, yes, definitely. And another big jurisdiction we cannot forget is Russia. So Charlene.
Come to the American for the Russian case. And I would like to start this off by saying I am not qualified in Russia. Please don't rely on this for any Russian advice. But why this case or why this jurisdiction is of particular interest is mainly because of one decision that was made in 2012, which if I have any former mooties on this webinar, you guys will be very familiar with the case. I'm saying the name in English. It's basically the Russian telephone company versus Sony Ericsson. And the asymmetrical clause that was at issue there was actually one involving arbitration. The asymmetry was that only Sony Ericsson had the option to choose to litigate a dispute if it wanted to. Now, the agreement between the parties basically was for the supply of cellular mobiles, and the Russian telephone company had objected to the quality that was provided, and they basically took Sony Ericsson to court in Russia. Sony Ericsson came in and said, nope, wait a minute, there's an arbitration agreement which provides for ICC arbitration in London. We want to remove the case and arbitrate instead. So because I don't read Russian and I haven't been able to find actually what happened in that relation, I don't actually know if the ICC arbitration was commenced. But I do know in this particular case, in the litigation, the lower courts, or the equivalent of the lower courts in Russia, basically found that it was fine. The parties had agreed to this type of an arbitration agreement. It was okay for Sony Ericsson to take it out and arbitrate the dispute instead. Once it got up to the no longer existing Russian arbitrage court, the court there decided that this type of agreement violated basically the parties' equal rights, and therefore it was not valid. It was not enforceable. Sony Ericsson could not take out the case and bring it to arbitration. The dispute should be litigated. Now, the reason why this case caused so much controversy is because it was quite clear that the parties, both sides were sophisticated parties who negotiated this arbitration agreement and agreed to it. For the Russian arbitrage court to make this decision kind of posed the question to the world of what happens in Russia. Are these types of asymmetrical clauses valid? Interestingly enough, in 2015, there was a subsequent case called Pyramida LLC versus Bot LLC, and there's a little bit of a twist. So they didn't overturn the Sony Ericsson case, but they did kind of carve out a rule, or basically a different type of following. The arbitration agreement in this matter, however, didn't actually specify Sony Ericsson, or in this case, Pirata has the right, not Pirata, that is a restaurant, Pyramida has the right to take the dispute out and arbitrate it. Instead, the arbitration clause provided that the claimant, or the party initiating the dispute, would have the choice to take it to either arbitration or litigation. And the Russian court in this instance said that the parties' equal rights were not violated because both sides basically had the ability and the right to initiate a dispute, and they could choose whether they wanted to take it to arbitration or litigation. To further strengthen this idea, in 2018, the Presidium of the Russian Supreme Court basically approved a review of jurisprudence relating to these state court assistance and control in arbitration. And what the Russian Supreme Court had said is that in general, if you have a dispute resolution clause that is asymmetrical and violates a party's equal rights, that is generally not enforceable. In this situation, they would normally make that arbitration clause symmetrical so that both sides would have equal powers. However, if this dispute resolution clause is drafted in a way where the parties' equal rights were not violated, so referring back to this Pyramida case, then the Russian court would view such an arbitration agreement or view such a asymmetrical clause as valid and enforceable.
Thanks, Janine. So it seems that among the civil law jurisdictions, the situation is more diverse, and the court tends to look into the contracts or the transactions more closely. We just mentioned about different grounds for challenging the validity of the arbitration clauses, these kind of unilateral options arbitration clauses. Brianna just mentioned the protective principles, the nature of the French court's analysis, and we also mentioned previously about the unconscionability, lack of mutuality, and maybe possibly violation of the EU law, things like that. So maybe we can discuss a bit further about these possible grounds for challenges, because if I the lawyer for the party who wants to challenge this validity, so what are the possible grounds that we could put forward? Perhaps Brianna first.
Yeah, I mean, I think they are the ones you've just listed. The common law cases I looked at, the English and the Hong Kong cases, actually don't seem to discuss lack of mutuality per se. That may be different, sounds like in Singapore. It seems to be more a case of trying to show that the clause isn't operable, or that if it's a unilateral jurisdiction clause, that it's not an exclusive jurisdiction clause that benefits the party that is trying to rely on it to get proceedings stayed. As I said earlier, to my mind, the French concept of clauses that are potestative, that come out of an imbalance of power between the parties, like a significant imbalance of power, seems to sort of run into the lack of mutuality concept, which in turn runs into the unconscionability concept, that it's essentially too unfair to allow this bargain to stand. But again, I think certainly between sophisticated parties, the courts will take a view that these are sophisticated parties. They knew what they were doing. They freely negotiated an imbalanced clause, and that's what they've agreed to, and they should be bound to it.
Revenue. The US will look at unconscionability of the contracts, right?
Yes, this unconscionability seems to be an argument that comes up a lot more from what I've seen, at least in the US. And I mean, there are two prongs to it under sort of American state law or contract jurisprudence, right? That's the concept of procedural unconscionability and the concept of substantive unconscionability. I guess procedural unconscionability means that sort of there's an unfair sort of bargaining power entered it into, it was some sort of contract of adhesion, consumer contracts. So these kinds of things are what would lead a court to say that a contract is unconscionable. And so I think, as Shirlene has mentioned, right, whenever we see these come up in sort of contracts of adhesion, courts are very offended by these types of clauses because they see it as a sort of depriving the consumer of their right to his day in court. And so you're right, this is an issue that comes up in the US. We haven't really seen it outside or like phrased in these terms.
And Janine, you have anything to add?
I think just maybe if we look at it, so if we look at it from the arbitration perspective, and I know I kind of go back to Arbitration 101 on this, but we all know this, consent is basically the cornerstone of arbitration. So for example, in the US cases where the courts have decided to not enforce such agreements, it's because you really haven't gotten the consent of this consumer or the employee, right? They've basically been forced into entering this agreement. And so I could see the reasoning on that. Whereas I have to be honest, with the Russian string of cases, the thing that just kept popping up in my mind, I mean, you've got Sony Ericsson and you've got this national Russian telephone company. They've clearly had top lawyers who have negotiated back and forth and agreed to this specific provision. For the court to overturn it because it violated a party's equal rights, that kind of, sings something to me. But in my opinion, I think the Russian court has kind of slowly gone towards a more favorable road in the eyes of perhaps international arbitration.
Can I add something to that, James? I think another Arbitration 101 point, and you referred to it, is the lack of equal treatment. And of course, the model law, the English Arbitration Act, most arbitral statutes enshrine very firmly the right of all parties to be treated equally. But it's interesting that the commentaries all seem to agree that that right only kicks in once the arbitration has commenced. It doesn't amount to a right to be treated equally when it comes to negotiating the arbitration agreement in the first place. And some of the English cases do discuss that and make clear that just because you have the right to be heard equally, to present your case equally to your counterparty in an arbitration does not mean that you have the right to be treated exactly equally in terms of the clause itself.
Brianna, that's a very good points to look. And I think that will bring us to the more practical aspect. So if we are the lawyers advising our clients, what should we look for when drafting arbitration agreements in cross-border transactions to make sure that we have all the clauses valid there? So any advice?
Helene, I'm going to actually kick that over to you first, given that China has recently, or appears to be changing its trend, and you're technically based in Beijing. What would you be advising your clients to watch out for? Can you hear me? Maybe that wasn't such a good idea. Can you hear me, Helena? No. Okay. Oh, we can't hear you either. You're muted. Okay, so we'll come back to you. Sorry, I tried.
Sorry, I couldn't hear you properly.
That's okay, I get to just repeat myself. So James was bringing us to the practical aspects of what would be recommended to the clients. And I thought, given that you had indicated that China seems to be changing the trend now in where they're going, the direction with the courts, and you being based in Beijing and a lot of your clientele being in China, what advice would you give to them with respect to drafting these types of arbitration agreements?
Well, if I'm the counsel, I tend to be more conservative, although we have already seen some jurisprudence in which the PRC court did admit the validity of an asymmetric clause, but we are not sure. There are so many courts in mainland China, and there had been some guidance rendered by the Beijing High Court, as I mentioned at the beginning, saying that an asymmetry arbitration clause is invalid. So if I were the counsel, I tend to be more conservative and would advise the parties agreeing to a more balanced arbitration clause.
Makes sense.
Yeah. But how about in other jurisdictions in Europe? You just mentioned Côte d'Azur in France. Look at the certainty, preciseness of some of these clauses. So what should we look for?
I think, what about if you look at it, Brianna, from the international arbitration perspective?
Yeah, I mean, I think, again, similar disclaimer, I'm not qualified in France or indeed in Hong Kong, but, we find in the international arbitration context that the clauses tend to be broadly similar, and it really is about drafting the clause very clearly so that it's clear who's entitled to exercise the option, when they're entitled to exercise it, and also what happens if the exercise fails. It needs to be super clear that there is a default option that applies to all the parties equally. I'm sure Nathaniel and Shalene have got some other tips as well when it comes to drafting.
Yeah, in terms of drafting, I mean, the validity of the arbitration clause would tend to turn on the law governing the arbitration clause. So I think what I would advise clients is to make sure that the law governing the arbitration clause is clearly stipulated and is the law of the jurisdiction in which such clauses have been found to be enforceable and valid. I think that's one way parties can sort of avoid sort of courts just invalidating them sort of nitty-gritty, right? Especially in light of NCAP v. Chubb and the latest line of cases. I think there's value in ensuring that the law governing the arbitration clause is clearly set out.
No, I agree. And I mean, one thing that I would recommend, because as I mentioned earlier during our interactive discussion, I have a number of clients that really like these asymmetrical clauses where basically they provide for arbitration, but then they say supplier or manufacturer has the right to go to the courts of the local jurisdiction of the buyer, and that's it, right? So they have that option to go to litigation. And it is enforceable in a number of jurisdictions, but what I would suggest or advise, because a lot of these clauses either come from the in-house counsel or our wonderful colleagues in, the transactional departments, please go and check with your disputes resolution counsel, or if you need, check with your external counsel just to see where the transactions are taking place, where you would likely enforce it. I do recognize that it is oftentimes, particularly for in-house counsel, hundreds of contracts may come your way for a day, per day. But what ultimately happens if you get that one dispute with that one contract that has an asymmetrical clause that may not be enforced, you will be spending millions on just the jurisdictional or the aspect of the dispute before you even get to the merits. So my suggestion is always kind of ask your fellow disputes colleagues.
Sure. Yeah, Piana.
It's worth putting into the clause a requirement that the party who's entitled to exercise the option give written notice to the other party before it exercises the option. Certainly in the common law cases I looked at, a lot of the disputes arise when the party with the option makes a claim in the optional forum and the other party comes back and says, actually, no, that's not valid, or tries to argue that because one forum has been activated, the clause then, the other part of the clause is then null and void. So for example, if they'll try and sue in the local court and then say that the arbitration agreement is null and void and inoperative. So you can eliminate a lot of that risk by writing into your clause that, the party with the option shall notify the other party, within 14 days before it intends to make a claim of the forum it intends to use. That doesn't give the other party the right to object, and because it doesn't have that right, but at least then it's clear to both sides what's going to happen.
Thank you. I think we have very good discussions, and the tips are pretty useful. I think that, as Janine has said, we should look at the whole transactions and the parties involved. So given the diverse practice in different jurisdictions, we have to be careful. So if it involves jurisdictions that do not use to uphold validity of the clauses, maybe Helena is why that we may advise the client to adopt a more conservative approach. But in some jurisdictions that uphold validity, that should be less a concern. Or in some uncertain jurisdiction, then we have to be very careful about the drafting. And also, as Bianna and some speaker has said, we have to prepare for the contingency. So what will happen next? So these are all very useful and practical tips. I think that is very interesting discussions. But we are running out of time because we have a little bit hiccup at the beginning, so we have to catch up for some time. So I think that is a good time we finish these sessions. And today we still have many more wonderful sessions coming up for the whole day. So I'm sure that you can ask questions and have more interactive discussions at a later stage then. So I will pause here, and before I end this session, conclude this sessions, I would like to give a big applause to our speakers and Helena on the screen as well. Yes, thank you very much.
everyone. Oh, I see we've got two lovely people on the screen. Welcome back to our second panel of today's 14th annual Generations in Arbitration Conference. Thank you guys for tuning in on panel one and dealing with our technical difficulties. We promise as the day goes on, it'll get better. What I am here to do now is to introduce you to the second panel with our moderator, Mr. Alex Yi, right over here. Alex is a lawyer and associate with Withers Worldwide here in Hong Kong in the Litigation and Arbitration Department. He will be our moderator for the second panel and introduce the rest of the panelists to you. So I will hand it over to him. Oh, sorry, no, I actually have one more thing to add. For those of you who do actually have questions for the panel, sorry, for the first panel, we still were experiencing technical difficulties. We figured it out from the second panel on. If you have a question, please go to the icon on the Hong Kong Legal Week homepage. There should be somewhere that you can click and you will insert your questions. The moderators will have access to them and address them as they come in. Thank you.
Thank you, Shirley. Good morning, good afternoon, ladies and gentlemen. Welcome to this year's GIA conference. As Shirley kindly introduced, my name is Alex Yin. I'm an international arbitration lawyer at Withers here in Hong Kong. I will be the moderator for this panel. Whose law is it anyways? What law governs an arbitration agreement? The question of how to identify the proper law of an arbitration agreement has been heavily discussed and debated among practitioners and academics for many years. Recently, this issue has once again come under the spotlight in light of the UK Supreme Court's decision in a case called Anka versus Russia. We are very fortunate today to have a panel consisting of leading experts, practitioners, and academics from many jurisdictions. In Hong Kong here with me, we have Ms. Xia Li and Mr. Ian Li. Xia is a senior associate in Walker's Insolvency and Dispute Resolution Group here in Hong Kong. Xia has extensive experience handling complex dispute resolution for clients across regions, spanning a broad range of sectors. Xia is also admitted to practice in many jurisdictions, including Cayman Islands, BVI, England, Wales, Hong Kong, and New York. Sitting next to Xia is Mr. Ian Li from the Department of Justice of Hong Kong. Ian is acting senior government counsel in the Inclusive Dispute Avoidance and Resolution, IDAR office of the Secretary for Justice office in the Department of Justice of Hong Kong. Before joining the IDAR office, Ian was posted in the Treaty and the Law Unit of the International Law Division, where he was responsible for advising the Hong Kong government on various public and private international law issues, and has practiced as legal counsel to the government in a number of international negotiations. Ian is admitted to practice as a barrister and solicitor in the Supreme Court of South Australia. Outside Hong Kong, we have Mr. Jun Bautista and Professor Kun Fan. Jun is counsel in King's Balding Singapore office. Jun has represented clients across a number of industries in international arbitration with a particular focus on Asia. Jun has been listed as an arbitration future leader by Who's Who Legal. He has also been recognized by Chambers Global and Chambers Asia Pacific and Legal 500. Jun is admitted to practice in New York and Philippines and is familiar with both civil and common law systems. Last but not least, Professor Fan from University of New South Wales, Australia. Professor Fan is Associate Professor of UNSW Law's Herbert Smith Freehills China International Business and Economic Law Center. Her teaching and research focus on area of ADR, online dispute resolutions, comparative legal studies, and law and society. Professor Fan has studied and worked in China, Singapore, USA, Switzerland, France, Hong Kong, and Canada. And she has also worked as counsel, legal expert, secretary for the arbitral tribunal, arbitrators, and domain name panelist in a number of international arbitration and domain name disputes. So as you can see, we have a very strong panel and very suited for this topic. But before we turn to our panel discussion, I think it might be helpful for me to give a very brief introduction on this topic, especially for the audience who are not quite familiar with arbitration. As you all know, the most common type of arbitration agreement is an arbitration clause contained in an underlying contract between the parties. It is also a well-established principle in arbitration that an arbitration agreement is presumably separable from the underlying contract in spite of being part of that contract. As a consequence, it is possible, although not necessary, for an arbitration clause to be governed by the law that's different from the law governing the underlying contract. So it is very important to identify the proper law of an arbitration agreement, also called AA law, because it governs issues such as the validity, scope, and the existence of an arbitration agreement, as well as its interpretation. Several approaches to determining the proper AA law have emerged across jurisdictions. One of the approach favors the law governing the underlying contract to be an implied choice of AA law. Another approach favors the courier law, which is the law of the seat of the arbitration, to be the AA law. Some jurisdiction like France takes a completely different approach, a so-called transnational approach. So in the first part of our session, I will invite our panelists to briefly discuss different approaches across different jurisdictions. And as I mentioned at the beginning, the UK Supreme Court recently ruled on this issue in the case Anka versus Chubb Russia. Maybe I will first turn to Xia to give us a brief introduction on the English approach.
Sure, thank you very much, Alex. It's a real honor to be speaking with such distinguished panelists today, and I think we're going to have a really lively discussion, especially in the latter part of this panel. So what we say is our personal opinion, not any advice, so feel free to let rip your opinions on this very interesting topic. So, as Alex mentioned, we have a recent case from the UK Supreme Court, Enka versus Chubb. It's been a very interesting decision in terms of determining what the law of the arbitration agreement is. So in that case, the claimant Enka entered into a subcontract with a Russian company to build a power plant in Russia. Now, the subcontract contained an arbitration agreement which required all disputes arising out of or in connection with the subcontract to be referred to international arbitration, seated in London and conducted under the ICC rules. However, the subcontract did not contain any express choice of law, and this was neither for the main contract nor the arbitration agreement. So what happened was, when they got into a dispute, Chubb Russia commenced proceedings in the Moscow Arbitrage Court against Enka and 10 other co-defendants. So these were the Russian proceedings. And in response, Enka issued an arbitration claim in the Commercial Court in London, seeking a declaration that Chubb was seeking an anti-suit injunction restraining Chubb Russia from continuing with the Russian proceedings. So this came to a head ultimately in the UK Supreme Court, and to summarize in a nutshell, the three main points which came out of the Enka and Chubb decision in the Supreme Court. First, it was held that the correct approach for determining the law of the arbitration agreement very much builds upon the three-stage test from the Sul America case from 2013. So the Enka case builds upon that. The second point is that where the parties have not expressly provided for the governing law, there will be a strong presumption that the law of the arbitration agreement will follow the law of the arbitral seat. So this is an interesting decision because previously there was, some uncertainty whether the governing law of the main contract or whether it was the governing this law of the seat would be applicable. And finally, a third point that arises from this case is that where the seat of the arbitration is England, the English court will always have jurisdiction for anti-suit injunctions in support of arbitrations, irrespective of the law governing the relevant arbitration agreement. So in this case, ENCA, they held that, the majority held that the subcontract was to be governed by English law, and following the law of the seat, that was the appropriate choice of law. I think this is a very helpful decision, especially in contrast to some certain civil law jurisdictions. For example, we've had some French cases, like the Kababji case, where there was quite a lot of uncertainty, which governing law there was. So I think it's very welcome clarification in this area of law.
Thank you, Sha. So it appears the English approach favors a law of the underlying contract to be an implied choice for the AA law. So maybe I will turn to Singapore and ask June to give us a brief introduction on the Singapore approach and see if Singapore court have adopted or followed the English approach. June, over to you.
Is the volume okay?
Yeah, we can hear you perfectly.
Okay, great. Thank you, everyone, for having me. It's a pleasure to be on this panel. So the position in Singapore has shifted a little bit over the years. So Sha referred to the case of Sul America a few minutes ago. Singapore has also referred to the case of Sul America as the starting point. Essentially, what Singapore courts have adopted is to use that three-stage approach, as Shah alluded to. But the difference initially was that in the first link decision, which was a high court decision, the Singapore court did not agree fully with the Sul America decision, in that the first link Singapore court disagreed that the law of the substantive agreement, or the law governing the underlying agreement, would be the implied, or the presumably the implied choice of the law governing the arbitration agreement. For the first link Singapore court, the better view was that the law of the seat of arbitration should be the presumable implied choice of the law governing the arbitration agreement. And the court gave two reasons for this. First, the court said that parties value neutrality. So parties choose the seat of arbitration because it is presumably neutral. Second, the court also emphasized that there is a desire for parties to ensure that the law of the arbitration agreement is compatible with the law of the seat of arbitration, which would have jurisdiction over the arbitration proceedings. So based on that ruling, for a few years there was a little bit of uncertainty. And then came the case of BCY versus BCZ. In that case, which is also a Singapore High Court decision, the court actually disagreed with the approach that the first link court adopted. And actually, it went back to the Sul America approach adopted by the English courts. The judge in that case actually criticized the first link decision by saying that it was actually unnecessary for the court to even go into that three-step analysis, because actually what's unusual about that case is that there's actually a false conflict. The three-step approach will only occur if there is actually a conflict between the law of the substantive agreement and the law of the seat. But in the case of First Link, actually, they were the same. And so the BCY court said it was just unnecessary for you to depart from Sul America when you didn't even need to go through that analysis. In any event, the court also said that it also disagreed with the reasoning or the rationale behind the policy rationale of the Singapore court in First Link. First, the court said a substantive choice of law can also give a neutral result. The Singapore court pointed out that actually parties often choose a neutral substantive law in order to govern the dispute. And second, the court also mentioned that while it understands that the First Link court wants to reconcile the any apparent inconsistencies between the law of the arbitration agreement and the law of the seat, the court pointed out that actually there are choice of law rules which must be applied, particularly the model law as well as the New York Convention rules. Now, this BCY versus BCZ case was ultimately affirmed by a recent Court of Appeals decision, BNA versus BNB, where the court endorsed the BCY case. The facts of BNA are that it involved an arbitration clause which provided for SIAC arbitration in Shanghai, and the governing law of the contract is PRC law. Now, the parties had a dispute as to whether or not that arbitration agreement was valid. One had basically contended that it is invalid because under the law of the PRC, parties could only choose arbitral institutions which are seated in China or which have their headquarters in China. The other party took the view that this was a valid arbitration agreement, given that the arbitration is a SIAC arbitration and that the phrase arbitration in Shanghai didn't necessarily mean that the seat of arbitration would be in the PRC. The tribunal actually applied the validation principle in this case and said, we agree with the party arguing that the arbitration agreement is governed by the law of the seat. The tribunal basically said, it doesn't make sense for us to interpret an arbitration agreement which would be invalid because it's clear that the parties had intended to go to arbitration. This obviously was a decision which the aggrieved party disagreed with, and it ultimately reached the Court of Appeal. Now, the Court of Appeal, again, in analyzing the decision of the tribunal and the High Court, basically said, yes, we apply the three-step approach as enunciated in BCY. And applying this approach, actually, the court said, we actually don't even need to go into this analysis because the three-step approach only occurs if there's a conflict between the governing law of the arbitration of the seat of arbitration and the substantive law of the underlying contract. In this case, if you may recall, the substantive law of the agreement was PRC law, but the arbitration clause provides that the arbitration will take place in Shanghai, and the Court of Appeal had ruled that that is actually an indication that it is the seat of arbitration. And in this case, there is no conflict between the two laws, and it's clear that the parties had chosen PRC law as the law governing both the substantive law, the seat of the arbitration, and the law of the arbitration agreement. Therefore, the Singapore courts have no jurisdiction. As a result of that, the Singapore court basically said it's really now up to the parties to decide what is next, because since Singapore is not the seat of this arbitration, the court actually has no jurisdiction over the arbitration proceedings.
Thank you, Jun, for your very detailed analysis on the Singapore position. So it appears at this stage, the English approach and the Singapore approach are to a large extent aligned. So both
Yes.
favors the underlying law of the underlying contract as at least an presumptive implied choice for the AA law. So how about Hong Kong? Now maybe I will turn to Ian to discuss about the Hong Kong position, see if all the common law jurisdictions are aligned in this regard.
Thank you, Alex. To start, I just would like to say that I'm very grateful and honored to be here with distinguished panelists talking about this very topical issue. And I would also like to say something about the theme of today's session, which is whose law is it anyways? At first, I thought that this was a play on the American comedy Whose Line Is It Anyways, where we're supposed to do an improv on different topics. But then some colleagues of mine actually drew attention to the fact that Whose Line Is It Anyways is actually a song in 1990 by a British musician called Guru Josh. I'm not sure if that was the intention of this panel, but I think the first line of the lyrics is very interesting because it actually reflects what we're discussing today. And it reads, "I'm living in a future of law. I want to know whose law can it be?" And the fact that it was written in 1990 and today we're discussing in terms of arbitral law, whose law is it? I still don't think we can answer this question. But with that in mind, I'll just turn to the Hong Kong position. So in Hong Kong, there's not a lot of cases that deal with this situation. And I guess to that extent is quite uniform in the Hong Kong court's treatment of this issue. So the main case is Kluckner Pentaplast and Advanced Technology. So in this case, the underlying contract was governed by German law with the arbitration venue in Shanghai and the arbitral proceedings to be held in accordance with the ICC rules. And the court was asked to rule the law of the arbitration agreement. So at the court of first instance, Saunders J. remarked that the starting point must be the terms of the particular clause and the contract in question, and that there is no rule that the lex arbitri must be the law of the seat of the arbitration. So in finding that the arbitration agreement was governed by German law, in this case, he basically quoted Dicey and Morris on the conflict of laws. And he quotes that if there is an express choice of law to govern the arbitration agreement, that choice will be effective irrespective of the law applicable to the contract as a whole. If there is an express choice of law to govern the contract as a whole, the arbitration agreement will also normally be governed by that law. This is so whether or not the seat of arbitration is stipulated, and irrespective of the place of the seat. So this quote and Saunders J's reasoning was confirmed by Tang VP, as he then was, in refusing leave to appeal in the same case. So this is the main case in relation to this topic. But recently, we have a case that was decided in March this year, and it was OCBC Wingham Bank Limited and Kaisen Shipping Company. And the underlying contract there was stated to be English law, with the arbitration clause reading, and I quote, "Arb, comma, if any, comma, in Hong Kong under English law." So it was a very short and succinct arbitration clause. So it went to the court of first instance, and the court there, after applying the principles, as I said before, in Kluckner Pentaplast, the court also concluded that since the governing law as stipulated in the arbitration agreement is English law, then the arbitral clause should also be governed by English law, notwithstanding the seat of arbitration being in Hong Kong. So I guess we only have these two cases, but they both contain an express choice of law clause for the underlying contract. So this follows the court's decision that the underlying contract law will also be the law of the arbitration agreement. But there hasn't been a case where there was no express law governing the underlying contract, so we don't know whether other approaches will be considered by the court if such a situation arises. So I guess that's the Hong Kong situation.
Thank you, Ian. So it appears that at least those three common law jurisdictions are aligned. If there's a governing law for the underlying contract, then that law will at least be the presumably implied choice of the AA law. Now I think it's a perfect time for us to turn to Professor Fan to give us an introduction on the civil law jurisdictions and see if civil law jurisdictions like France or China have adopted a completely different approach. Professor.
Thank you. Could everyone hear me well?
Yeah, we can hear you.
Okay, thank you, Alex, and good afternoon, ladies and gentlemen. So it's a great pleasure for me to be able to join this exciting event virtually. And so after the panel, the other co-panelists have already introduced a common law approach. I will just briefly talk about the French law and the Chinese law approach. So the French law actually approached this issue quite differently. It takes a rather transnational approach, which gives the full autonomy of the arbitration agreement. So as we know, the principle of autonomy or separability of arbitration agreement is a quite acknowledged principle internationally, also recognized under English law, but the French law goes further and acknowledges that the arbitration agreement is autonomous from any domestic law as a consequence of the separability principle, and therefore directly subject to just the general principle of international law. And such a transnational approach was established in France through a series of decisions by the French Cour de Cassation, and including the landmark case of the Dalico in 1993. So in the Dalico case, the Cour de Cassation have chosen not to apply a conflict of law analysis when determining the validity of an arbitration agreement. And that approach is also taken in the recent KPG case, as we've seen the English court and the Paris Court of Appeal have adopted quite contrary positions in this case with respect to the law applicable to the arbitration agreement. So in this case, the parties has entered into a franchise development agreement, which contained an arbitration clause that expressly provided for English law to govern the main contract, and then referred the dispute to ICC arbitration seated in Paris. And as is often the case, a party made no express choice of law to govern the arbitration agreement. In January 2020, the English Court of Appeal found that on the proper construction of the franchise development agreement, the party had expressly indeed chosen English law to govern the arbitration agreement. But quite contrary to the English approach, just 6 months later, on the 23rd of June, the Paris Court of Appeal ruled that there was no express choice of English law to govern the arbitration agreement, and that in the absence of such express choice, the proper law of the arbitration agreement should be French law, which was the law of the seat. And in coming to that conclusion, the Paris Court of Appeal applied the very well-known French approach, recognizing the full autonomy of the arbitration agreement, and stated here that pursuant to a substantive rule of international arbitration law, the arbitration clause is legally independent from the underlying contract in which it is included, either directly or by reference, and its existence and validity are interpreted subject to mandatory rules of French law and international public policy, only according to the common will of the parties, without the need to refer to any national law. So with this approach, it further held that the choice of English law as a law governing the main contract was not sufficient to establish the common will of the parties to submit the arbitration clause to English law, and to derogate from the substantive rule of international arbitration applicable at the seat of arbitration. So we can see that the French approach is quite different. It takes a rather transnational approach and avoided the application of the conflict law rules. Now, the PRC position on this matter, it's set out under Article 18 of the law of the PRC on the choice of law for foreign-related civil relationship, according to which, in the absence of the parties' express choice, the applicable law to the arbitration agreement is considered to be the law of the seat or the law at the place of arbitration institution. Here, the reference to the place of arbitration institution might be a bit confusing, which is essentially due to the lack of recognition of legal seat in the arbitration law drafted in 1995. But now, the legal consequence of the seat of arbitration has been increasingly recognized in China by the courts. So in the recent decision, like for instance, the case of BNA, BNB that Jun just mentioned, there was a debate about whether the proper law of the arbitration agreement should be Singaporean law or the PRC law. And Jun already mentioned the Singapore approach, and so in October 2019, the Singapore Court of Appeal overruled a ruling by the High Court and decided the natural meaning of the phrase arbitration in Shanghai should be interpreted to be the seat of arbitration is in Shanghai. Therefore, the default choice of Singapore as the seat under the SEAC rule is not applicable here. And interestingly, the Singapore court also decided to leave the issue on the validity of arbitration agreement to the judicial review of the PRC court. So subsequently, the Shanghai First Intermediate People's Court decided that the seat of arbitration in this case should be Shanghai, and therefore applied the PRC law to determine the validity of the arbitration agreement. And it also held that according to the PRC law, the arbitration agreement should in fact be valid, and therefore confirming the validity of arbitration agreement designating a foreign arbitration institution in China, along with the Supreme Court's earlier decision in the Longli-de. So in this case, the Shanghai court stated there was no restriction under PRC law that foreign arbitration institution cannot administer arbitration seated in China, which has been a debate over the years. So that confirmation was a welcome one, and therefore this validity argument that the law of the main contract, in this case a PRC law, should be displaced by considering the invalidation effect of the PRC law on arbitration agreement also become remote in light of this confirmation from the Shanghai court. But on the issue of law applicable to the arbitration agreement, the Chinese law approach seemed to be, according to this PRC conflict law rules, that in the absence of party express choice, the applicable law of the arbitration agreement would tend to be the law of the seat. So that's just a brief overview, and I look forward to discussions.
Thank you, Professor Fan, for the excellent summary of the civil law positions. Now that our panelists have already set out different approaches in different jurisdictions, in the second part of the session, I will pose a few questions for a discussion. Professor Fan just mentioned the doctrine of separability, which I think is one of the underlying reasons divide the position between common law jurisdictions and civil law jurisdictions. The question I will pose to the panel is, what should the scope of the doctrine of separability be? Should it be an arbitration agreement be treated as an independent agreement for all purposes, like the French approach, or only for the purpose of determining the arbitration agreement's validity? Maybe I will ask June to start the discussion.
Back. There's like, okay, can you hear me?
Yes, we can hear you. I think there's a bit technical problems on our end. Maybe while we are trying to fix this ASAP, maybe I will turn to Xia. Maybe Xia, you can start the discussion.
Sure. So I think the answer to this question very much depends on which background of law you're influenced by. I would say in general, if you come from a common law background, it tends to be that you would consider it less as a purely independent clause, but more as something used to, as you say, to support the main contract. So I think maybe Ian can also comment on what you think from a Hong Kong perspective.
No, I agree. It depends on the background, and I would also like to draw attention to it. I think it also depends on the domestic law regime. If there's arbitration ordinance or act. So in Hong Kong, Section 34 of the Hong Kong Arbitration Ordinance, which incorporates Article 16 of the UNCITRAL Model Law, basically states the common law background approach and says that it's only for the validity, etc., and not as like a separate whole contract. So I guess that's the Hong Kong perspective.
June, can you hear us now?
Yes. Although I didn't hear Xia's discussion, but I did hear Ian's. And yeah, I actually echoed that approach. It is basically, I think, it is a function of domestic law. And most, I think, jurisdictions would have incorporated, let's say, Article 16(1) of the model law, for instance. So I guess that is your starting point. Whether or not you can interpret that further, I guess that is probably a function of either legislation or courts.
Professor, do you have a different opinion on this?
Yeah, sorry, I also didn't hear very well the first two speakers, but I intended to agree with the French approach, which give the full autonomy of the doctrine of separability, basically to treat the arbitration agreement as a legally independent document from the main contract, so that it can also be autonomous, in fact, from any domestic laws, just subject to general principle of international law. I think that's probably also because of the education that I received, and I tend to agree with the third representation that advocated by Professor Emmanuel Guéa, according to which the source of validity and legitimacy of the process is not based on a national system, but on an autonomous arbitral legal order. So I think that approach is probably more consistent with the international character of arbitration.
So let's maybe focus on the reasoning on the common law approach. Say, at least under the common law approach, the scope of this doctrine of separability is at least for the purpose of determining the validity of an arbitration agreement. But in that case, shouldn't the relevant purpose also include at least for determining the AA law, given that the validity of an arbitration agreement is normally governed by the AA law? Maybe I can ask June to start the discussion first this time.
Sorry, can you say that again?
Yeah, so under the common law approach, the purpose of the scope of the doctrine of separability is for the purpose of determining its validity, and so if we take that approach, shouldn't the relevant purpose at least also include determining the law of arbitration agreement, given that the validity of an arbitration agreement is governed by the law of arbitration agreement?
I guess I guess we can sort of, I don't know if we can, I agree with you that the doctrine of separability, of course, I guess, I agree that the common law approach takes the view that the separability doctrine insulates the arbitration clause from being invalidated on the basis that the main contract is being assailed or impugned, because without that, then you can easily undermine the purposes of the party's intent. But I don't necessarily agree that you can extend that, to the extent that you can actually use the separability doctrine to basically then say that will have an effect, or that has much influence on the arbitration agreement. I guess maybe my approach is in contrast to Dr. Van Koon is, I guess I think the common law English approach is a little bit more appealing to me, because I can sort of see that parties, when they negotiate and draft these arbitration clauses, they don't really think about what are the laws applying to the arbitration agreement. They don't even know that there's a separability doctrine. They only know, the arbitration clause is part of the contract. And when they designate the governing law or the substantive law of the contract, normally that's it. They don't actually refer to a different law. And even the concept of a seat, I think most lawyers, corporate lawyers, they don't even think of the law of the seat as actually having any bearing. They just think, the place of arbitration is where we're going to have the hearings. So my instinct is that the approach, at least taken in Sul-America and the Singapore position, is more commonsensical. Let's put it that way. It's something that's more commercial.
Professor, any rebuttals?
Yeah, sorry, I would like to sort of raise a contrary opinion with my friend Jun. So I think that, I agree that we could interpret it with a sort of common intention with the parties, but I kind of agree with what the Singapore court held in First Link case, that it cannot really always be assumed that commercial party want the same system of law to govern their main contract, which is governing the relationship, performing substantive obligations, right? So like, for instance, they chosen a certain contract law, and whereas quite separate relationship of resolving dispute, when more commercially sensible view would be that the later relationship often come to play when the formal relationship have broke down, right? So I think it's kind of two set of relationship. When they have agreed on the law governing the main contract, it's really what party have in mind is the law governing the substantive relationship, which is quite separate from the law that governing, resolving the disputes. So I think we cannot make a natural inference that commercial party would want the same system of law to govern the two distinct kind of relationships. But just for the sake of a discussion, I'm sure there are also different views as we see different positions taken by the courts.
Maybe I will briefly invite Ansha and Ian to see which side you guys on.
I think in general, the parties are very commercial when they draft. I think this sentiment has been echoed by the other panelists. They don't necessarily take an academic approach when they are deciding the law of the arbitration agreement and the main governing law. So I think as lawyers, when we parse it after the fact, it's maybe somewhat removed from what the parties intended?
Well, I share, as all common lawyers do, the views of Jun. But I would also like to add, it also depends on how you see the doctrine of separability, what it entails, and what it's meant to do, its purpose. So for us, the doctrine of separability is meant to separate the arbitration clause in the event that the underlying contract is allegedly terminated or defective, so that parties can rely on that clause to manage their disputes. So in that sense, I would say that this approach is correct in that it should only be governing matters such as validity and dispute settlement and all that.
So we can actually see a clear division between common law lawyers and then civil law lawyers. But maybe I will pose the next question for the benefit of all the legal practitioners, because actually it's my personal experience when we have this issue on the governing law of an arbitration agreement. If the problem occurs in a real dispute, the first question a lawyer needs to ask themselves is what law as a starting point should be applied in deciding the AA law, because the answer will have a real consequence, as we just saw the different approaches taken by different jurisdictions. So should it be the law of the seat, or governing law of the main contract, or even the law of the forum, depending on which court is deciding on this case? I know Professor Fan probably favors the view that it shouldn't be any domestic law. It should take the French approach, whereby the existence and scope of the parties' common intention should be the point of analysis. So maybe I will ask Xia to start this discussion.
Yeah, I think Professor Van Koon will probably disagree with what I have to say, so I welcome her views very much. I think the French approach of taking the common intention is perhaps a step too far, just because a lot of the times the parties don't necessarily have a common intention, and to construct that out of it is perhaps somewhat artificial. I think my view is that there's no perfect answer in determining the law. You know, whether you go with the seat or the governing law, there's always some benefits and some drawbacks. So it's interesting to see how different jurisdictions have determined it. But I'm interested in hearing Professor Fan's views on the common intention point.
Professor, any comments?
Yeah, I might just sort of advocate my proposition of this transnational approach. I think it's because, as we have seen, different jurisdictions have taken different approaches. The conflict laws leading to quite confusing and contradictory and inconsistent decisions. So I'm in favor of this sort of more transnational approach, which avoided this necessity to apply any conflict law rules, and then just determine this with limit of public policy. So in that sense, it's not a complete detachment. So didn't go as far as Professor Geya has gone to have a totally detached arbitration agreement. And I think this detached approach is also endorsed in arbitration practice, right? So for instance, in this Dow chemical case, where the tribunal have also decided that under the chosen ICC rules, since the agreement is a separate agreement from the main contract, the tribunal could decide on its own jurisdiction without being bound to apply any specific law. So that's, again, based on the idea that the tribunal is not obliged to apply conflict law rules or substantive rules of any given country, and just relying on substantive rule of international arbitration. So I think the transnational approach tends to give effect to the party's intention, and also more in line with the pro and enforcement objectives of New York Convention, and could avoid some inconsistent interpretations by different courts.
I think Professor mentioned a very important point, is to avoid inconsistent decisions, as we already saw in the Kebab J cases, and the French court the starting point of French courts analysis is French approach, and then the starting point of English courts analysis is the English approach. But I want to add on that. So in reality, if this question does come before a tribunal, what arbitrary tribunal the starting point of analysis should be? Because if we're following the UK Supreme Court's position in ANCA, the starting point should be the law of the forum. But what is the law of the forum when the tribunal is deciding the cases? Maybe I will ask Ian to start the discussion first.
Thank you, Alex. I think the question to follow on from my previous point is how you see the separability doctrine. And in my view, which does not represent the Department of Justice's view, I would think that since the arbitration clause is only there to provide dispute resolution mechanisms in the case of the breakdown of the main contract, the underlying contract should be a good starting point in relation to determining the law of the arbitration agreement. And I echo Alex's point that yes, it has to be consistent in order for clients, in order for businesses to know how and what to draft in their arbitration, and what to expect if a conflict arises. But I think it's quite a lofty goal. If this consistency is expanded to worldwide, what the worldwide practice is. So for the time being, I think it's good enough if we know how individual jurisdictions rule on this particular question.
June, any supplements?
Yeah, I think Ian and I are of the same view. I think for me, while a national approach is, has the benefit of, uniformity and consistency, I think at this stage, most jurisdictions, many, arbitrators, I think will find that a little bit too radical. I think most of us and most judges of courts still think of arbitration as linked to a territory, linked to national laws. Of course, you can think of international law, but it would still be part of domestic law, whether it be a treaty or general principles of international law or customary international law. But to say something like, the international public order requires this, I think we're not there yet. And I think you need to take baby steps. And I don't think we can go there immediately. Let's put it that way.
I still see the division between the common law and civil law approaches. Hopefully, let's see whether my next question will bring more consensus among our panelists. So let's talk about the validation principle, which is referenced by both common law courts and civil law courts. And in the UK Supreme Court, actually in ANCA, viewed this validation principle as that contracting parties could not reasonably have intended a significant clause in their contract, such as an arbitration clause, to be valid. It views that this principle as a form of purposive interpretation which seeks to interpret the language of the contract in a way which will affect the purpose of the parties. But in other jurisdictions, in some civil law jurisdictions, this principle, the scope of this principle is much wider. I will give you one example. For example, Section 178(2) of the Swiss Federal State of Private International Law provides that the arbitration agreement shall be valid if it conforms to either the law chosen by the parties or the law governing the subject matter of the dispute, or if it simply conforms to Swiss law. So in your view, which approach is the correct way of implementing the validation principle? Maybe I will start with Professor.
Okay, I think so. In general, like this validation principle, as you introduced, it requires selection of national law which would give effect rather than invalidate the party's intention to arbitrate. And I think this validation principle is consistent with this effective interpretation principle, and also in line with, again, the pro-enforcement objective of the New York Convention and the model law. The Swiss law goes goes a step further, I think, than any traditional sort of conflict law approach. Basically, the validity of the arbitration agreement will be upheld if it complies with requirement of the least demanding of those three rules that mentioned. But in practice, I think the analysis always starts with the Swiss law because it's generally very pro-arbitration, and I think there are very rarely cases where the Swiss court will hold the arbitration agreement is invalid under Swiss law, but valid under a foreign law. So that is a quite, I think, a pro-arbitration approach. In practice, though, I can think about potential issues when it comes to enforcement in other countries under the New York Convention, right? Because the invalidity of arbitration agreement, according to the law chosen by the parties, could justify a refusal of enforcement. So there might be potential problem of enforcement. But in general, I think the Swiss approach is quite a pro-arbitration attitude to validate the party's intention, and it's a welcoming one.
Thank you, Professor. Does any other panelists share that view? See if we can bring any consensus within the panel?
I think you're unlikely to see consensus on this question as with the other ones. I think I appreciate the Swiss law approach very much. I think, again, it's quite radical from a common law perspective, I would say, their approach, especially in light of arbitration meant to be a freedom of choice of the parties in determining what they want and how they want to resolve their disputes. I think with the Swiss approach, there might be a risk of trying to construe an arbitration agreement to a place where it is not, where it is so flawed that it can actually be implemented. For example, Ian, just now earlier you mentioned there was a case where the arbitration language was very limited. It was like, I think you said arb, comma, right? So if you have a situation such as that, sometimes it may not be possible to adopt such a pro-arbitration approach just because of the way that the agreement was drafted.
Ian, any thoughts?
Well, I would take a very radical view, and my view is that we should step even back and question whether the validity principle or rule should actually be such a principle that should be applied in arbitration. Because if we look at, for example, the case you just mentioned, OCBC, it's just a very vague and short and unclear arbitration clause, and I'm not sure whether it is preferable if courts try to validate this kind of arbitration clause. And I think we also have to look at the practicalities of courts in dealing with this issue. For example, correct me if I'm wrong, June, but the High Court decision in BNA and BNB did just that. They actually, whether expressly or impliedly, tried to apply the validation principle, and in my words, forced the arbitration, law of arbitration to be Singapore law, which was overturned by the higher courts. Now, Professor Fan has already most helpfully given us the results of the validity of this arbitration in the Chinese courts. But at the time that the Singapore courts have ruled on this issue, they took the view that if the governing law was Chinese law, it would invalidate the arbitration agreements. So I guess, in my view, that we should really take a step back and question whether it is desirable for courts to actually rigorously apply the validation principle. So that's my extreme view, if you may.
June, your view?
I guess to sort of illustrate my view, I'd like to actually ask a question: is why do we single out arbitration agreements as having some sort of special quality that merits this quote unquote validation principle, where I think the principle of effective interpretation or the validation principle, these are actually rules of contract interpretation, I mean, to a certain extent. So that those principles should apply to other types of agreements, other types of contracts. And I mean, query whether or not, why are we actually putting arbitration agreements, up a pedestal?
So your view is we can't treat arbitration agreement as too different from a normal other type of agreement. It's just an agreement. So doesn't.
I mean, unless you can show me why that it merits this special treatment. I mean, it is ultimately just another agreement.
I tried to bring some consensus to the panel. Apparently, was not very successful. I think it was the perfect time for us to bring some questions from the audience. We actually have a few questions from audience, so we'll read out for the panel. The first one being, in light of the international origin of model law jurisdictions, any real issue arising from the inconsistency in judicial decisions on the law governing arbitration agreement, should consistency be called for? I think we already briefly touched upon this issue. And if I remember correctly, Ian, your view is it's good enough for now that we know each jurisdiction's position is. But how do you answer this question then?
Yes. Hello? Yep. Yes, I do think, well, firstly, I think that consistency is important. But also we have, as June mentioned, it is quite difficult to have a worldwide kind of consistency in relation to the treatment of these arbitration agreements. And different courts from different legal traditions will always, I might say that they will always decide things differently in light of their legal training, their background, and how they perceive the arbitration agreement and party autonomy. So for me, and I guess for June as well, it's good enough for now that we have some consistency in a particular jurisdiction so that we know when we go to that jurisdiction, we can expect those kinds of results.
But I guess the following up question is, but for those jurisdictions that adopt the model law, and should consistency be called for, at least among these jurisdictions? And maybe I will invite Professor to give her view on this follow-up question.
Sorry, I have some difficulty hearing you very well. Can you say that again, the question?
So the question is, so at least for the countries that adopt model law, shouldn't, at least for these countries, consistent approach should be adopted?
Yes, yeah, I would certainly advocate for at least an attempt. I agree with Ian that different courts would still, despite this harmonization trend, there will still be different approaches influenced by their legal training. But I think we I would advocate at least an attempt to harmonize and to ensure the consistencies and to avoid, and also to enhance the predictability of the outcome for the parties. So I think at least this is a goal that we should achieve, but I agree that, in practice, it's probably still inevitable that even different arbitrator, even within the same, under the same law, right, arbitrators still influenced by their own cultural background. And the same, let's say the same Chinese arbitrator who get the trainings in Hong Kong, or who were retired judges, or who received the training in Germany, would probably still apply the same law differently. So I think like uniformity is not the goal, and arbitration is more beautiful because of diversity. But I think the goal to ensure the at least some predictability, we should also endeavor to provide some harmony and some consistencies, and in particular, model law and New York Convention strive to achieve that a certain level of harmonization.
Sha, any supplements?
I would say the way to avoid the consistency issue is to draft a good arbitration agreement. But then if we all did that, we would have nothing interesting to talk about. So, no, on a more serious note, I think, having a good arbitration, well-drafted, good language is really important. We see this in the Enka case, where the court said that, there's no bright line distinction between having an express and an implied choice of law. And I think sometimes you see that in arbitration agreements. It's not so clear-cut whether they actually specified that. So it's an interesting point to bear in mind when we look at interpretation of these agreements.
June, I see you nodding when Professor was giving her views. So is it the first time we can see the alliance between you and Professor?
I think mine would be a little bit more nuanced. So, so the approach that I'm actually perhaps going to refer to is actually an approach that the ANCA UK Supreme Court decision, cites, is that actually you might want to consider the New York Convention as a starting point, because the New York Convention has actually applies to both arbitral awards in Article 5 and Article 2, which refers to arbitration agreements. Now, you've got a choice of law rules with respect to Article 5(1)(a), which says, we will give effect to the validity of the arbitration agreement which the parties have subjected to, which have agreed to, or failing that, we will apply the law of the seat of arbitration. So that actually gives you the hierarchy. Parties can agree, and of course, that agreement, if you apply at least the UK or English decisions or the common law jurisdictions, that agreement can either be express or implied. I don't know whether or not the civil law jurisdictions have an implied agreement, whether you can use that, but at least at the very least, there is this thing called parties can agree, whether or not it's express or implied, if we apply the common law approach. If there is no agreement, then we go to the seat of arbitration. So I think, again, that is a good starting point.
Thank you, Jun, and also to all our panelists for their excellent answer. That actually we are actually perfect on timing, and that brings us to the end of the panel discussion. And thank our panelists for their excellent engaging discussion and brilliant input. And more importantly, thank all the audience that tuned in, and hope you enjoy the rest of the GIA conference, and hope to see all of you next year again. Thank you.
Thank you.
Thank you.
Sorry, thanks, guys. Am I still on? Am I still on or am I off? 人家外面听得到还是 I just actually want to make a comment. Can it's just a comment, sorry, just so the participants know. Yeah, I could talk. Okay, so everyone, as you know, we've got the lunch break now, so go enjoy some nice food and drinks, and please meet us back here online in about an hour, 1:30 p.m., I believe.
Hong Kong first introduced mediation as a voluntary resolution process under the civil justice reform in 2009. Ever since that, Hong Kong has been at the forefront in the development of mediation in the region. From domestic to international, individuals to multipartite, and with the increasing use of technology to facilitate the process. Join me in the webinar series of the Hong Kong Legal Week to find out more about these latest developments, including the launch of the Judiciary's Case Settlement Conference Pilot Scheme, the application of mediation in investor-state disputes, sport-related matters, and ways in which you can improve your mediation advocacy skills.